But at least for the legal reasoning and the interpretation of the rules, it's important that we have a kind of jurisprudential line that we can follow and apply all the time. And finally, because we try to be quicker, we try also to save some money for everyone by simplifying these procedures. Some procedural issues. First of all, because it's a first instance, the question is who will be the claimant or the applicant, and this should be normally the international federations, or during the period of the games, it should be the International Olympic Committee. As I said, maybe together with the International Testing Authority if they have the mandate to represent the federation. The Anti-Doping Division has the power to determine whether there is an anti-doping rule violation and also decide on any sanction. And finally, the hearings also, we try to simplify this in order to avoid, I would say, lengthy time limits to organize a hearing to make sure everybody is available. So we can also have a hearing by video conference or possibly no hearing at all. Or now, and it's something also new, I will come back to this later, a possible hearing with the presence of the public. The question is now whether we have a panel of one arbitrator or three. Sole arbitrator is the rule. It's a rule by default. So this arbitrator, who will be appointed from a special list, shall be selected in agreement with the parties, and only in case there is no agreement, then the president of the CAS ADD will make the choice. So that's the principle. When we have a sole arbitrator, there is still a right of appeal before the normal CAS. And if the parties request a panel with 3 members, that's possible. And then the deal is, if the parties want 3 members in the panel, they should also accept to waive their right of appeal in order to have a sole instance. So if we have a panel of 3 arbitrators, all specialists in anti-doping regulations, the goal is to have only one single decision and no further appeal, save for a possible appeal before the Swiss Federal Tribunal that we cannot exclude, obviously, but at least it goes quicker at the beginning. There is a little additional remark here. If the parties want to retain the right of appeal and still have 3 members in the panel, we will not exclude that possibility, but the parties will not benefit from any financial assistance to cover the arbitration costs. It means, in other words, that the parties will have to pay for the services of the entire panel, while if we have a sole instance, there will be a participation of ICAS to cover part of these arbitration costs. We have an exception to the waiver of the right of appeal because we cannot exclude the right of appeal of the World Anti-Doping Agency. It is in the World Anti-Doping Code. There's a little contradiction here, but the World Anti-Doping Code, which has been approved by all stakeholders, will be maintained, and I think it's the only exception which would allow an appeal even in that situation. Regarding the list of arbitrators, we have the general list, as you probably know, with the ordinary division and appeals division. The arbitrators on the CAS general list are still able to deal with any of these procedures. There is also the football list, which is a sub-list of this general list with specialists in football matters. And now we have the CAS anti-doping division list, which is a special list, and the arbitrators in that list are no longer able to sit in appeals cases. Whatever the matter is, whatever the topic is, in order to avoid a mix of the 2 populations. So it's a bit new, but on the other side, these arbitrators on the ADD list will be able to deal with ordinary procedures, which, as you know, it's a sole instance. Inside the anti-doping division list, and that's also new, we have a protected list of panel presidents. The goal is to maintain this list of presidents not eligible by parties, also to maintain some independence to the institution. So the presidents will act as sole arbitrators, obviously, or are panel presidents. And to add a little bit more complication, in that list of presidents, we also have a list of arbitrators able to deal with the question of compliance with the World Anti-Doping Code. This is more institutional, and probably you have read in the recent news about the investigation in the Russia anti-doping system, that there may be issues about compliance with the World Anti-Doping Code, and that could be typically a question, if there is a problem, that the World Anti-Doping Agency could refer to CAS, and that in that situation we would use this list of non-compliance issues. These lists are being finalized and will be published, I think, in a few days on the CAS website. We are waiting for the last biographies to upload the list on the website. The right of appeal, as I said, IOC, the World Anti-Doping Agency, the national anti-doping organizations, according to the World Anti-Doping Code, have a right of appeal against CAS ADD decisions. And the appeals, nothing new, are filed in accordance with the Code of Sports-related arbitration, 21 days, and then it's a classic appeals procedure. We maintain also the system of the legal aid and the pro bono lawyers for the ADD. It means that, as I said before, we have a group of pro bono lawyers, which is moving a bit with new people and people leaving, but we have, I think, 40 or 50 names on that list. We try to cover all continents. These lawyers are available to represent athletes before the CAS ADD, if need be, and they agree to work for free, which is also important. And CAS, or ICAS, I should say, on the other hand, is also prepared to bear some arbitration costs or some expenses for the athletes, like the travel and accommodation costs, up to a certain amount. This would facilitate the access to sports justice. And as long as we have enough funds, we maintain this system to help access to the CAS. The signatories so far, because I forgot to say that this system of the CAS ADD is, of course, a voluntary system. It is a service which is at the disposal of the federations. We have now 7 federations having accepted this new jurisdiction. So triathlon was the first, archery, skiing, shooting, luge, rowing, and bobsleigh skeleton. We know that probably 2 or 3 more should also join this system by the end of this year. And hopefully before the Olympic Games in Tokyo, we will have another group of 6 or 7 federations. We understand that this system is really, I would say, helpful to the middle-sized and the small federations, probably not to the big federations, which are organized already with different anti-doping panels or authorities. But that's the beginning, and the goal was really to provide a service to those federations which believe that spending money and energy in these matters may not be necessary or useful, and could have a simple way to delegate these missions to the CAS anti-doping division. So that would be more or less the presentation, a quick overview of the CAS ADD, and I will spend another probably 10-15 minutes now also to discuss about other aspects of the recent evolution of CAS and ICAS. First of all, because we also have to prepare our move to the new premises. It takes time because we should be moving in October 2021. But I'm confident that we will go from a chateau of Béthuzy, that you probably know already, to the Palais de Beaulieu. It looks a little bit big, I agree with you, but we will use only one part of this palais, which is a convention center. It's the part on your left. It's the south wing. So the south wing is the entire wing divided by 2. So the last part, say the last 5 windows, will be the CAS area. The ground floor will be occupied by a restaurant, and we will have the upper floors on this side. It's a good side because we are with the view on the lake, and it's quite good also because the metro will stop there in probably 5 years. So it's a good system for us to be here, I mean, in Lausanne, to remain in the city center, and to have also bigger premises because we will at least triple the surface of the CAS offices. We should have 3 hearing rooms, plus many meeting rooms, a cafeteria. There will be an auditorium, not as big as this one, but we will have a system where we can also accommodate some conferences, and we can still use also the convention center, which is on the other side, for the bigger conferences if necessary. So the final picture may be this one, with a new floor added to the building. We may not have this sign, the green sign at the top level, but it shows a little bit how the new CAS will look like. Also, the front part will be more pedestrian zone, and the access will be the second door from the corner. So this is the future. It takes some time also to coordinate the work and to tell the architects what we want to have inside the offices. It's kind of special job, very interesting, but also very demanding. So that's the picture for the future. I show you another hearing room, which is probably bigger than the one we will have. This is the European Court of Human Rights, because even if it's now almost a year ago, it was the 2nd of October 2018, there was an important decision coming from this body. The ruling on the Pechstein and the Mutu cases versus Switzerland, an interesting case. You read it already. The Pechstein case took a long time. You have all the episodes on the screen. In green, it's the Swiss chapter with the CAS award in 2009, then followed by an appeal at the Swiss Federal Tribunal, followed by another appeal in case of a revision of a first decision, which was also denied. And then there's the German chapter, where we have the claims before the first instance in Munich, second instance, and finally the German Federal Tribunal. The German chapter was important for CAS because it was the determination as to whether CAS the CAS award would be applicable also outside Switzerland. So the question is whether or not the German courts would have jurisdiction to re-entertain the same case, or the case. So the first 2 decisions in Munich were not favorable for CAS, and the last one, which was welcomed as a nice surprise because we were not so sure that the German Federal Tribunal would overturn the first decisions. So it was a nice surprise because it recognized that the CAS award was applicable, so the jurisdiction of CAS was confirmed, and that the CAS system was also confirmed in its entirety, because you remember that the arguments raised by Claudia Pechstein was not only against the CAS panel rendering the award, but more generally with the system of CAS and ICAS, saying that the ICAS people were strongly represented by sports federations, had an influence on the arbitration procedure, and so on. So in the end, it was a good conclusion. We had this decision of the European Court of Human Rights also confirming that the CAS system was acceptable. We didn't have a big round of applause from the European judges, but at least they accepted the fact that the CAS system was applicable and could be justified. And there was one exception to the, I would say the success of this procedure. I will say it now. But we are still waiting in Germany for a last decision to come, which is the decision from the Constitutional Court of Germany, which is dealing with the appeal of Claudia Pechstein against the decision of the German Federal Tribunal in 2016. So this last part, we don't know the end of the story. Hopefully it will be also a positive conclusion, but we are hoping to have this decision next year, if possible. Just take a glass of water. Thank you. Technical break. And coming back to the Pechstein ruling in Strasbourg, one ground in the decision was to say, and it was favorable to the arguments raised by Claudia Pechstein, that normally CAS hearings should be held in public if an athlete so requests. We said, and even before waiting for a possible appeal before the Grand Chamber of the ECHR, which has come but was denied immediately. But nevertheless, the ICAS has decided to change its regulations and the CAS regulations by adopting a new rule that you can have on the screen, the new Article 57 of the code, saying that now, because the public hearings were already possible in the past, but the condition was that both or all parties involved in the procedure would accept this public hearing, which was very rare. We had only one public hearing in the history of CAS. It was the case of Michel Smith de Bruyn, Irish swimmer, who had a problem with the doping case and requested a public hearing, which was accepted by the Swimming Federation, FINA. But since then, it was in 1999, we had no further requests or no further agreements. So now, with this new rule, for the new procedures in 2019, we have a possibility that if the athlete, and the athlete only requests a public hearing in a disciplinary matter, CAS should organize it. So it's not a big issue for us, on the contrary, because we can also show in transparency what we are doing. The challenge is more on the logistical side, because obviously the CAS hearing room is not big enough to accommodate some public. And we have actually a request for a public hearing, which should come in November, so soon. And it's probably a hearing where we have more than 2 or 3 people. It's the case of the Chinese swimmer Sun Yang. This case is filed by the World Anti-Doping Agency against a decision issued by FINA, the Swimming Federation. It's the case of the Chinese swimmer, Sun Yang, who has decided to interrupt a doping control, saying that there was a mistake or an error in the protocol, in the procedure. So he decided to destroy the urine samples and to annul the test, I would say, physically. So this situation was not sanctioned by FINA, but the World Anti-Doping Agency considers that it is not for the athlete to decide whether the test is valid or not, and has filed an appeal, which will be heard in November. The date and the location will be announced very shortly, but we anticipate that this will bring some interest among not only the media, but also the specialists of sports law and international arbitration. Then maybe a word, because the Pechstein case also helped the ICAS to rethink of some evolution and some, I would say, improvements, especially with respect to the criticism that sports, I would say, sports officials would have too much space in the organization. Also, the ICAS board would have too much power in the decisions making around the arbitration system. So first of all, the new ICAS appointed in May this year. We have still 20 members, but only 5 of them exercise a function as an official in sports organizations, which is a change compared to the past. We have more judges, more lawyers and professors of law. So the majority of them are coming from outside the sports movement, but still interested and still have a good knowledge of the sport in general. But at least they are not linked with organizations. In terms of gender equity, we are almost there with 9 women, 11 men. We had 10 and 10 2 years ago, but now it's 9 and 11, so it's quite a good result compared to other sports organizations. And we have new commissions. The first one is a challenge commission to deal with all petitions for challenge against arbitrators. During an arbitration procedure, if one party considers that an arbitrator is not independent, so this party may file an application before this new commission, which is chaired by the former Chief Justice of Brazil, Ellen Gracie-Northfleet, and accompanied by the division presidents who are not involved in the selection of this arbitrator. So this is a new body, and it's no longer the ICAS board dealing with these issues. The second commission existed before. It has been reshaped. It's the Legal Aid Commission, deciding on requests for legal aid filed by athletes. The ICAS president is still the president of that commission, but the other members are all the members appointing to safeguard the interests of athletes among ICAS. So it gives a large proportionality in favor of the athletes, I would say, interests. And only the president is there to understand also what money is spent in terms of legal aid, because of course, if we have 50 or so requests for legal aid, and I would say maybe 40 of them are accepted, in the end, the invoice is quite large for ICAS, and we need to make sure that the legal aid fund is sufficiently, would say, provided with enough money. So this is the composition. And the last commission is the membership commission, which is the body in charge of accepting new CAS members and also removing CAS members from the list. It has been in function for the first time this year. It is chaired by the federal judge in activity, Judge Reeb. So he's totally separate from any sports organizations and is totally independent. So that's, I think, a very good system. And we have also Ms. Tricia Smith, who is the former president of that commission, who is a former Olympian and also now an IOC member, and the 3 division presidents. And I think that I covered almost everything, and I will give you also the floor to ask questions. I show you on the screen the progression of the number of CAS cases registered by CAS. You can see that in the last years, we had a kind of ceiling of 600 cases. This year should be also the same. Probably in 2016, the big number was because of all the cases brought in relation to the Sochi 2014 cases, with a lot of Russian athletes coming to CAS. So the progression was a bit too fast, probably. 600 cases this year, and probably because of the Olympic Games next year, there will be a little bit more. I'm also anticipating that with the anti-doping division, we may get also some more cases coming. So I will stop here because I think I would like to also hear your questions or comments if you have. And also I would like to give enough time to Michele so that he can cover also the CAS jurisprudence later. So thank you very much for your attention, and I'm available for questions.
Tiempo para hacer preguntas para Matthieu, si hay alguna. Tenemos micrófonos preparados. Si hay alguna cuestión, si no, pasaríamos a la siguiente ponencia. Por aquí una pregunta. Leemos el micro un segundo.
Thank you very much. So maybe a question about the Matthieu-Pechstein case. I can understand that it is quite a big victory for the CAS, but according to me, there is quite a flaw in the decision of the Court of Human Rights, because they said, yes, CAS, it is a court installed by law, but they give a very specific and also not so good motivation about installed by law. And there was also the different opinion of one of the judges who said, yes, that is a flaw in the decision of the human court decision. So what do you think about that? that CAS is installed by law. However, it is not quite installed by law.
With the European Court of Human Rights, we have a mix of different judicial cultures, even in Europe. Eastern Europe, Western Europe, North and South. And I think one of the criticisms raised by some judges was the fact that it's not totally institutional in terms of installed by law by the states. But arbitration is a private system. So in Switzerland, at least, we would never imagine that there would be a specific law installing CAS as an authority dealing with sports matters. So it's not something that we may change being in Switzerland. What we have tried to cover is all the other remarks concerning the independence and the composition of the different authorities within ICAS. But regarding the legal system, at least it is compatible with the Swiss law system, compatible with the Swiss constitution. So even if the Swiss judge was in the minority in this European Court decision, we think that there was no reason to change the legal framework around CAS. But there was an appeal by Claudia Pechstein before the Grand Chamber, which was stopped immediately at the beginning, because you know that the president of the court has the right to say, yes, this matter can go further or not. If he said that the matter should not go further, it's probably because he considered that enough was said in the first decision. Okay.
I'm not afraid that it will be challenged in the future, the authority of CAS.
There may be further challenges, but probably not for the same reasons. Yeah.
¿Más preguntas por aquí? Aquí en el pasillo.
Gracias. En su presentación usted ha sido muy cuidadoso de plantear unos aspectos nuevos de esta posibilidad de la sala de dopaje, del tribunal de dopaje específico. Pero en nombre de los que padecemos al CAS, con el tema de la capacidad misma de llamar que este es un tribunal voluntario, cuando en los estatutos federativos se establecen que las decisiones de las federaciones pueden ser recurridas ante el TAS cuando los deportistas no tienen la capacidad económica para fijar esos gastos, me parece que de voluntariedad está obligado. O sea, los deportistas ni participamos en la elaboración de los reglamentos federativos de cada federación, de cada deporte, y finalmente tenemos que asumir un costo que es absolutamente arbitrario, injusto y que termina denegando justicia en virtud de estas decisiones federativas de poner al CAS como segunda instancia. ¿Cuáles son las alternativas que tiene un deportista reales cuando no tiene los recursos y se está denegando justicia? Finalmente, no tiene posibilidad de recurrir una acción que considere injusta, y más cuando en algunas federaciones establecen que el solo hecho de ir a la justicia ordinaria de su país puede generar sanciones en contra del deportista, como sucede en el caso de mi país. Entonces, ¿cuál es esa brecha? ¿Cómo piensan ustedes que se puede cerrar? Porque finalmente termina siendo un sistema de denegación de justicia por los altos costos que tienen que asumir los deportistas para poder ser escuchados y no tienen los recursos.
I think there are two issues. The problem with the financial resources to appear before CAS, and the fact that there's a double instance inside the institution. I hope I understood the question. Concerning the costs, as I said, I tried to be clear. We have this system of funding, a pro bono system, where athletes can request legal aid. It means that if they want to proceed before CAS, or if they have to defend also, they can request legal aid. The goal is not to oblige them to spend all their money in these procedures, something which we understand, and this is the reason why we have this legal aid system. So normally, athletes should not complain for this, because if they go to civil courts, they would have to pay for their lawyers, they would have to pay for the cost of justice of the tribunal. So I think that's quite a positive sign. Regarding the double instance inside the institution, I don't know if it's the problem you raised, but I can say that the first instance of CAS is composed of people who are different from the appeals body. So we have two different groups of arbitrators. Even if it's the same institution, but it's also why you have seen we have different premises and different staff. It's a separate organization in terms of practice. And an appeal is possible before CAS, and then there is still an appeal possible before the Swiss Federal Tribunal in case there are any procedural failures or a problem regarding jurisdiction, for example. You may say that it's better to maintain the previous system where we have a federation dealing with first instance cases, but this is a service we offer. What we think is a good system. We will see in the future whether it works or not, but I'm confident that it's a good alternative. Federations are free also to maintain the system and to keep on going with the internal authorities, but it's a choice which is available.
Vamos a otra pregunta por aquí.
Yes. Hola. Sí, aquí está.
Primero aquí.
Patricia Meyerson. We could see that the system is really improving. I'm talking about the CAS system and through the new ADD system. But still, I have a question. Could you tell us if there are some criteria which are used to nominate the arbitrators on the list or to remove them? Is there some criteria? If yes, what are the criteria?
On the ADD list or the general list?
All the lists.
All the lists, okay. Well, the criteria is obviously for the arbitrators to be interested in the activities of CAS, to be available for CAS. We have situations, for example, where arbitrators are on the list but cannot be available to deal with arbitration matters expeditiously. It's maybe not their priority, so this is a situation where the membership commission could say something like the arbitrator finally is not really involved in the CAS activities. We also notice sometimes, because it's true that this membership commission does not interview every candidate. We get approximately, I would say, 100 candidatures every year, and obviously there is a work of selection which is made on the papers. And sometimes when an arbitrator declares that he or she speaks 4 or 5 languages and actually she doesn't speak English or French, but we discover this during a procedure, it doesn't work, so we cannot accept that. And of course, when there is a problem regarding the qualities and the capabilities of an arbitrator which are not there, the membership commission would not renew an arbitrator like this. In terms of quality, we don't have I would say strong criteria, and the membership commission is quite open and flexible, because what is a good decision, what is a bad decision is very subjective, and we should not also have an opinion on that, which could be interpreted as a sanction against an arbitrator who does not deliver good decisions, because this is quite subjective. But at least when the arbitrator is not efficient, is not available, or does not comply with the CAS regulations, it happens sometimes that an arbitrator wants to change the system or does not want to comply with the deadlines and so on. Obviously, there is a decision here which is negative for this person.
Yeah.
Thank you very much for the presentation. I have relevant questions related to the pro bono lawyers program. So is the list for the ADD anti-doping division separate from the general list and also the ad hoc tribunal for the Olympics? And the second question is, because I followed very closely the application procedure for such pro bono lawyers list, but I haven't really found what is the procedure to be registered as a pro bono lawyer. So I would like to know, for example, what is the status for the selection of such list for the Tokyo Olympics next year, for example? Mm-hmm. Thank you.
I start with the end of the question because in Tokyo we have already organized a group of pro bono lawyers with the Tokyo Bar Association. I think it's Japan Bar Association with Tokyo, and they have already a group of 30 pro bono lawyers that they are now training for the games. So this group should be available. I should say that we do not select the pro bono lawyers ourselves when we are dealing with these games because we don't want to interfere in that selection, and we don't want to be part of. We don't want people to say that CAS has organized also the defense lawyers for the athletes. So we delegate this task to the Bar Association, and they can prepare these pro bono lawyers available during the Olympic Games. For the general system, so the classic CAS and the ADD system, we have a group of probably 50 of these pro bono lawyers who are applicants who have spontaneous applications, and we examine whether these people fulfill the criteria to be active in that list. So mainly the question is whether they are attorney at law and they can represent properly athletes before CAS. We are not so strict in the selection because the goal is really to offer a system where the athlete can choose the lawyer. It's not CAS which determines which lawyer should go with which athlete. The athlete receives a list and can select the lawyer of his or her choice.
Next question at the back. Al fondo.
Sí. Hola, ¿qué tal? Buen día. Buen día. Quería hacer dos preguntas muy breves. Una, su opinión sobre el caso Guerrero, sobre el fallo del Tribunal Federal Suizo, si le pareció que fue un fallo win-to-win, si se quiere, con el ADR, y plantear también si es la inmediatez el caso que lleva al CAS por ahí a violar, si se quiere, como decía el colega recién, a un derecho fundamental como es el acceso a la justicia.
On the Guerrero case, my advice is not to drink too much coca tea, I think, because it can create some bad surprises. I cannot comment really the outcome of it. I can only say that it is in line with the regulations applicable at that time. The 6-month sanction given by the FIFA could not be confirmed. It was either 0 or 12 months or even more than 12 months. But 6 months could not be confirmed, so because there was no such a sanction provided in the rules. This is the only thing. I feel sorry for the player because obviously it was a difficult situation, but in the end, I think he was lucky enough to be part of the FIFA World Cup 2018, and later he was suspended, but at least he could save one part of his objectives. And the second question, I'm not sure I understood it, but if it's regarding access to justice, I think I have already answered about the use of pro bono lawyers, the fact that there is a financial assistance also provided, and the fact that most federations now have implemented the right of appeal in favor of CAS. The question probably is whether it is possible also to go before other tribunals. Well, with the arbitration clause, normally not. We know some exceptions sometimes, but probably, and this is still my personal conviction, it is really in the interest not only of the federations, but also in the interest of the athletes and the players to have quick justice. Even if the decision is not favorable or is not exactly what was expected, at least there is a decision. And you know the situation and you know what to do in the future. If you are waiting for 3 or 4 years to know the outcome of a procedure, it is probably more harmful. So there are good and bad in the system, but I think it's rather more in favor of the parties and of the players.
Hola, hola. Sí, Matthieu, buen día.
Buen día.
Respecto a la ayuda legal, legal aid en general, ¿cuál es el motivo por el cual no se le confiere la posibilidad de ayuda legal a los clubes, sabiendo que hay muchísimos clubes del mundo que no tienen el suficiente respaldo para hacer frente a un procedimiento ante el TAS? Y la segunda pregunta es si existe la posibilidad que en el futuro se incluya la ayuda legal para clubes.
Good question. It's rather a political decision to choose to help physical persons and not legal entities like clubs or federations. It's true that many clubs or federations would probably also need some financial assistance. But the fact is, if a club is not able to deal with its own finances and just wait for a kind of fiasco to have the assistance of CAS to go before that court, probably we may have to create a fund of a few billion of dollars because many clubs in the world have financial problems. So it's more, I think, a political question. It's a good question nevertheless, and I don't know if this is something that FIFA or other institutions consider, whether it's necessary or not to also provide some assistance of that kind to the clubs. But at least for CAS, the legal aid is limited to physical persons for the moment.
Okay. No más preguntas? No more questions? Okay. Thank you, Matthieu.
Thank you.
Un aplauso para él. Thank you.